Ben Meiselas and Karen Friedman Agnifilo here from Legal AF. We have some breaking news that the Second Circuit Court of Appeals has denied Donald Trump's attempt to assert an absolute presidential immunity defense in the E. Jean Carroll second defamation case, actually the first filed case, the second to go to trial, scheduled for January of 2024. And the Second Circuit Court of Appeals ruled on the grounds of waiver. In other words, Donald Trump, you and your lawyers did not assert as part of the affirmative defenses you have to list when you get sued absolute presidential immunity. Sure, you tried to substitute in the United States in place of Donald Trump, and that's what went through all of the courts of appeals for a very long period of time. But you never listed the defense of absolute presidential immunity. And now that you're trying to do it 3 years later, as you're headed to trial that's just about damages and punitive damages in January, after you were previously found liable for statements and conduct that was made when you were not in office. This is for the conduct made in 2019 when you were in office. It's too late, buddy, is basically what the Second Circuit Court of Appeal says. And Karen, you and I were having a discussion about that, and we said, let's do this as a duet because there's a lot going on with presidential immunity and this concept in Washington, D.C. proceedings involving Trump asserting absolute presidential immunity as a shield against the criminal case against him, where the federal judge says, nope, absolute presidential immunity does not apply in criminal cases against former presidents during the conduct while they were in office. There was also a recent D.C. Circuit Court of Appeals case, the Blassingame case, that said Donald Trump's conduct on January 6th does not fall within the doctrine of absolute presidential immunity that does exist in civil cases, because his conduct relating to the insurrection involved election activity and campaigning, and that's not even within the outer perimeters of executive authority. And now you get the Second Circuit case in a defamation case for statements Donald Trump made while he was in office, during press conferences and during other interviews while he was in office in 2019. But the Second Circuit Court of Appeals is ruling on a narrow ground of waiver. Buddy, you didn't assert this as a defense for 3 years. You and your lawyer, thank Alina Habba for this. You waived it. It's gone. Karen, what do you make of all of this, the decision by the Second Circuit, and then this broader issue of absolute presidential immunity that's been coming up over and over again?
Yeah, Alina Habba really screwed this one up, right? I mean, this is a big miss to learn on to lose, I should say, on a you didn't raise it 3 years ago claim. That's kind of brutal as a lawyer, right? Especially if you're a former president of the United States' lawyer, that you missed your number one affirmative defense, which is presidential immunity. And so that's a huge miss for her. And, look, she has a mixed bag of experience. She's not very experienced. So it's unclear why she's even one of his lawyers in such a prominent spot, because experience and good lawyering matters. And this case is, I think, prime example of why that's so important, because this literally was the Second Circuit, which is the appellate court that oversees the Southern District of New York, which is the federal district court, which is the lower trial court. So it's the step before the Supreme Court. They're the ones who ruled on this because E. Jean Carroll is being heard in New York in federal court in front of Judge Lewis Kaplan. And this particular case, if everyone's head is spinning saying, I don't understand, wait, all these immunity cases are going on and all these presidential immunity cases, I don't blame you if your head spinning, because as a lawyer, I am even finding myself reading and rereading and saying, how does this case square with that case? And how does this argument square with that argument? Because even though for example, the DC Circuit and the Second Circuit aren't necessarily binding on each other, it's not like they don't read each other's decisions. And certainly the Supreme Court looks at everything, and all of these things are going to go to the Supreme Court because this is foundational, right? This is whether or not he's immune, whether it's civil or criminal. Can he be sued or can he be prosecuted? This is something that has to be established once and for all of these cases. And as you said, the DC Circuit in Blasingame clearly ruled that if it's outside the outer perimeter of his job, he can be sued civilly. And so that case is going forward. And then we got the Tanya Chutkan decision in the criminal case, saying, like, hours after the Blasingame case came, because don't forget the DC Circuit's her boss. And even though the DC Circuit in Blasingame said, we're only ruling on civil, we're not touching criminal, I'm sure she still wanted to know, what are they going to say? And so she ruled hours, like her decision was already ready. And she probably just added that one case for some of the propositions that it said. And that and her case, the criminal case, was appealed interlocutorially, right? Which means there are two kinds of appeals. There's the kind of appeal that you can do after you're convicted. If you're convicted, then you can appeal. Or you can sometimes, in very limited circumstances, appeal midstream, right? You can appeal while the case is still pending. And those types of appeals really only happen in certain circumstances. Those types of cases, the law is very, very limited on when you can appeal midstream. And here it was really, I think, interesting because on the one hand, we are arguing that that this is so important, right? That this is such an important thing that, you should be able to appeal it. Because so Nixon versus Fitzgerald, which is a case from, I think, the 70s or early 80s, is really one of the first presidential immunity, actually there were some other cases, but that's sort of the leading Supreme Court case that talks about presidential immunity in civil cases and this outer perimeter test, meaning if it's within the president's duties within the outer perimeter, then they are immune from civil suit, right? And so that talks about it. But in Nixon, right, in Nixon versus Fitzgerald, the Supreme Court basically said, okay, look, the collateral order, meaning the appeal in the middle, appeal during the pendency of the trial, this doctrine of being able to do that comes from a case, Cohen versus Beneficial Industrial Loan Corp. And it said it's a small class of interlocutory appeals that are allowed if it conclusively determines the disputed questions, resolves an important issue completely separate from the merits of the action, and are effectively unreviewable on appeal from final judgment, and it has to present a serious and unsettled question. So without a doubt, this does that, right? Because if he's immune, the suit can't go forward. If he's not immune, it can, right? Like it's decisional, it's foundational, and it's really important. And that's one of the arguments that Jack Smith uses as to why, for example, in the Supreme Court, he filed a writ to hear before the petition or in advance of a judgment, of the appellate court judgment, meaning in the Tanya Chutkan case that we just talked about, right? In that denial of presidential immunity, Jack Smith is at the same time leapfrogging the DC Circuit and appealing to the DC Circuit, having them both go at the same time, saying, this has to go. It's so important. It's foundational. He even concedes that it divests the district court of most of her jurisdiction because we have to decide this. It's so foundational. And so he makes that argument, and that's why he also says to the Supreme Court, this is so important, you have to hear this, you have to do it, you have to make it fast, and you have to do this. This is one of those few rare times where this is so important, you have to do it. And I buy that, right? I think that's absolutely true and clear, which is why when I read this decision that we're talking about now in the Second Circuit, right, where we're talking about the E. Jean Carroll case, why I was scratching my head a little bit that the Second Circuit would say, look, you waived it. you waived it, that this is waivable, because there's certain things that aren't waivable, right, Ben? There's certain things that no matter what, you cannot waive. And the fact that this is one of those things that's so important, so foundational, the case can go or not go, but then you can also waive it by failing to raise it. To me, it's a little bit logically, a little bit head scratcher. And what the bigger head scratcher for me is that they didn't then go to the merits. Sometimes they'll say, even if we find that this was not waivable, we still find that, X, Y, and Z, he doesn't have immunity because it was outside the bounds. Like, courts very often do that, right? They'll find something on, like we see it all the time in criminal cases when somebody waives the right to appeal. They take a plea and they conclusively waive their right to appeal. As a prosecutor, I don't respond to that appeal by saying, when they do appeal, I don't respond and say, oh, they waived appeal, sorry. I take the time and I say, but even if the court finds that they didn't waive, they lose on the merits. And the court rules on that. They rule that it's waived, but then they'll turn around and say, but if they didn't waive, even if they didn't waive, we still lose on the merits. And so it kind of surprised me here that they really just hung their hat on this. It's been 3 years, which is kind of ridiculous, by the way. And, it is ridiculous that she did not raise it and that it took 3 years. And clearly it wasn't strategic. She just didn't know, or, she's just so incompetent, frankly, that this is why she's in here. But this one, I was a little bit worried that the Supreme Court, who's going to be reading all these decisions, might find it a little bit logically inopposite. I don't know. What did you think?
Well, I'll say this. In the Blassingame case, the civil lawsuit that Trump tried to argue falls within the outer perimeter of the office of the presidency, the January 6th related conduct. They did assert the absolute presidential immunity, not just as an affirmative defense, but as a motion to dismiss. They raised the issue right away as a dispositive issue. Similarly, in the Washington, D.C. federal criminal case, Donald Trump raised that right away, raised the issue right away. And I do think if Trump did not raise the issue in Blassingame, did not raise the issue in the criminal case in Washington, D.C., and it proceeded to trial, and then on March 3rd, Karen, the day before trial, then Donald Trump says, aha, I have absolute presidential immunity, and goes through all of the steps. Though I do think there would be a similar analysis, because just think what that would ultimately inspire. It would inspire that bad conduct right there, which is you drag the proceedings until the very end. You do nothing. You sit on it. You prejudice the plaintiff, or you prejudice the government, and then you just wait. And then, Karen, what about if you do that before verdict? What if you go through trial and then you go, aha? So taken to its most extreme examples that I give, I think you can see why there does need to be some sort of waiver doctrine, and you have to assert this thing. It's not something that's, jurisdictional per se. And one of the things where something is jurisdictional, the court on its own can do what's called a kind of a sua sponte ruling and just say, I don't even have jurisdiction over this. I've heard enough facts. Explain to me why I should even hear this case in the first place. So I do think there is cohesion between the cases. Blassingame, Donald Trump asserts it as a motion to dismiss. The criminal case being prosecuted by Jack Smith, Donald Trump files a motion to dismiss the indictment. Those two are similar. But then you go to the New York case where Alina Habba and his stellar legal team does not assert absolute presidential immunity, basically until last August, in response to an amended complaint. And there it was stricken by the judge. And the judge says, no, you can't do this now, 3 years later. That's something very easy for you, for you to bring then. So
You
that
raise an
that's
excellent point, which is that if it is the court's going to the Supreme Court is going to decide, is this jurisdictional or not? I mean, that's really what this is going to boil down to. And if it's not jurisdictional, frankly, one could ask, then how is it appealable interlocutorily? Like, again, that's the thing I'm talking about is this jurisdictional? Is this not? And that's kind of a case. This will be a thing of first impression, I think, and why the Supreme Court will ultimately take up all these cases and consider them, knowing that even if they only take one case, and that's the Jack Smith criminal case, I think they're going to know that this issue is ripe generally and has wide implications for all of these cases, because it's a real issue. It's not frivolous.
But if you think, though, about all of the other types of immunities, that whether it's a prosecutorial immunity, you can't charge a prosecutor for what they do in the course and scope, but there are limits there, or a judicial immunity, or various other immunities that exist in the law, or if you even talk about other issues that are heard on
Right.
a
Those are waivable.
right, and then if you other issues that are dispositive, for example, the issue of is there an arbitration provision, arbitrability, that's waived if you don't assert the arbitration provision. So, and that's something that's heard on an interlocutory appeal. So I think what the Second Circuit is saying, look, this was so easy, this was a layup. Just literally, when you list the affirmative defenses, we know we talked before about kind of checking the box, although there was some dispute about whether in the New York Attorney General civil fraud case there is a box or not, whatever. But here, it really is basically a check the box type of issue. Your affirmative defense isn't this
Especially if your
elaborate.
client's the president, former president.
It's actually one sentence, right? You say, and for the sixth affirmative defense, absolute presidential immunity. And then on a summary judgment, you've now preserved it. You bring it as a motion for summary judgment, and or you bring it up as an affirmative defense, as a question of fact for the jury, whatever it is, you've at least preserved it as an affirmative defense. So that's why I actually think what the Second Circuit did was a relatively easy call based on Alina Habba's screw up. The more interesting and fascinating question, though, would have been, okay, let's say if Donald Trump did assert that early and on time, then, what would have happened then? Does the conduct that he engages in a press conference defaming E. Jean Carroll fall within the outer perimeter, the same way in Nixon versus Fitzgerald, the unlawful termination was found? Well, that's bad conduct, but executives do engage in conduct like terminating people, so we're not going to allow civil liability here. My view is that Judge Kaplan, the federal judge who already rejected the argument by Donald Trump that the United States government should be substituted in, saying that the conduct was outside the course and scope of what the role is of the presidency, would find something similar, that defamation is outside the outer perimeter. But Karen, it is a different analysis, a kind of course and scope analysis versus an immunity outer perimeter analysis is a different analysis. And I could have seen everybody getting upset at the outcome, where a circuit court of appeals presented with the issue of, does a defamatory statement by a president, even a heinous and despicable one, not the sexual abuse happened before he was in office, so there would never be immunity for that, but the defamatory statements within the court, at the time of the presidency, what happens there? That's a fascinating question that I would like to have resolved as, of course, you should be held liable for defamation. But I think, if I'm being fair here to what I think the Circuit Court of Appeals may have done, I think they could have found that to be Fitzgerald-like conduct and actually dismissed the case, and everyone would have been outraged. But I think that was a plausible outcome. But the Second Circuit didn't even have to get there, because they're like, your lawyer screwed it up.
Well, yes, I hear everything you're saying, and if the Supreme Court were, frankly, legitimate the way they used to be, I wouldn't even be raising any of the concerns that I'm raising. It's just that the Supreme Court today packed with the Trump appointees. You just don't know. I don't like to leave any room for them to find anything. And that's really, like I said, I wouldn't even have mentioned this if this was prior to Trump. And you'd be like, oh, thank God for the Supreme Court, because they're the grownups in the room who will fix problems, who will reconcile differences in circuits and really interpret the law in a way once and for all that is mostly respectable. And so when I read this, I thought, oh no, don't give them any room to for any of their arguments. So that was my only concern there.
Well, there you had it, folks. A law class by Karen Friedman, Agnifilo, and myself, getting really deep into the weeds here on the issue of absolute presidential immunity when it applies, how it relates to the Second Circuit Court of Appeals decision, and why it is, though, that this really was a monumental screw up. Whether it was Alina Habba or some other lawyer at that time, you don't get bigger screw ups than not asserting the immunity that you're supposed to assert.
Especially because it's going to cost Trump millions.
Yeah, I think that verdict in January is going to be to the tune of tens of millions of dollars. Yes. But we will keep you posted there. Karen, always love our duets together. Meidas Mighty, Legal AFers. Make sure you're subscribed to the Legal AF podcast and subscribe to the YouTube channel. Let's get to 2 million subs by the end of the year. Ambitious, but we can try. Have a great one.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.